Hey, everybody, and welcome to Thursday night. We are here each and every week where we do a live stream and answer your questions relating to debt problems, bankruptcy, wage garnishment, debt collection lawsuits, all that kind of stuff. I'm John Skiba. I'm an attorney in the state of Arizona. I help people file bankruptcy, and I also defend people from junk debt buyers like Midland Funding, portfolio recovery, all those people. So the format that we do tonight is if you have a question, we want this to be a discussion. You can put that in the chat area, put the question in there. I put it up on the screen and we can talk about it and kind of give you some pointers, maybe some resources on how to deal with some of these debt problems. Now, as always with the disclaimers, even though I'm a licensed attorney in the state of Arizona, I'm not licensed anywhere else. I don't know the laws everywhere else. And so anything that we're doing here cannot be considered legal advice. We've likely never met. I don't know the specific facts of your case. I highly recommend you consult with an attorney in your particular state to get some legal advice as far as how your courts deal with things and the general process. If you're in the state of Arizona, of course, you can give me a call. My website's down there at the bottom, and you can get information. We can set up a consultation where I can give you specific legal advice, but this should not be interpreted as that, or it should not be, it doesn't create any type of attorney-client relationship. So, all right, we're going to go ahead and get started. Man, look at this, right out of the gate. Marcos, thank you, as always, each and every week for being here. I appreciate you supporting the channel. All right, let's talk about a couple things that I had. Something I've been doing that's been kind of good. I try to respond to comments in that I get on the channel. There's a lot. And so I do my best to try to respond to each of those. But so I'm going to start pulling some of those comments and we can deal with them directly here on the Thursday night live streams and try to go over some of those questions there. Looks like we already have a bunch here. Let's see here if we can throw some of these up. Let's take a look at this one here. Hi, it says, we've responded to the debt collector's attorney's lawsuit. Do you think they'll do an interrogatory next? So I can tell you it's possible. They absolutely could. I could tell you, so if you file the answer, you've done more than 95% of people who are sued by a junk debt buyer. So congratulations. Nice job. You're well ahead of the curve already. And so usually what happens next is within about a month or so, the parties have to exchange something called initial disclosures. Now, in some states like Arizona, they actually have to provide you with copies of their exhibits and documents. In other states and many federal jurisdictions, they just require that they provide you a list of potential documents, witnesses, that kind of thing. They may start to do some discovery. What I see more often, now the plaintiff or the debt buyer, the creditor, they probably think, and it's probably true, they think we have everything we generally need. They may not do a whole lot of discovery as far as written interrogatories, which are just written questions. The one thing I do see them do quite a bit is they will submit something called a request for admission. Request for admission is a discovery tool that's used in civil litigation where it's really just where you want to ask the other side yes or no questions. And so they'll say, admit that you owe us $6,000. Or whatever, or admit that we are the correct owners of this account. And you have to check the box, yes or no. And there's a timeline to send it back. Now, this is kind of a trap, then they know about this. Requests for admissions are the one discovery tool. If you don't file a response timely, the court can deem those requests admitted. And so sometimes I'll see a debt buyer will send those over with really basic questions like, admit that you owe us the full amount, admit that you owe us a bunch of attorney's fees. And then people don't respond to them, and then they file that as an attachment to a motion for summary judgment. So they may do some discovery after that, but you got to be careful. If they do send over some requests for admissions, make sure that you respond to those timely. All right, let's see Benny here. Sent a motion to compel arbitration, but a hearing was still set. What should I expect during the hearing via Zoom? I guess the question is if the hearing is, if you're saying it's like a trial, if they sent you need to get a ruling on it first. If the court hasn't ruled on your motion to compel arbitration, then you can contact the court, make sure they have it, make sure that the judge has seen it. If they just haven't ruled on it, you can file another motion called a motion for summary disposition, which is a motion just basically saying, hey, judge, there was a motion here. We need some kind of ruling on it. It may be that they set that for oral argument. That's what I see a lot with these motions, is that they will file the court will want to ask some questions about it. So that may be what the hearing is for. If that's what the hearing is, then you need to be prepared to explain why you think that it should go to arbitration. And basically, you're just looking at that arbitration agreement that the debt buyer, the creditor provided to you, or it's part of the underlying contract, and just point to that and say, that's why. That's why it needs to go. If it's trial, that's a whole other thing. If they're bringing you in for trial, kind of beyond the scope of what I can do in this kind of video. But look, I have a whole bunch of other videos on the channel about how to deal with trial, cross-examination. I even have an online tutorial. I linked that up to the top of the chat there. If you want to take a look at that, that would be a good thing to take a look at, because I have a tutorial that's like how to deal with trial from day one until the whole thing's over. All right, let's see what else we have here. See what Spidey time. Let's do this one first. Can I ask for arbitration now or wait until they actually sue me, the attorney? Usually there's got to be some kind of dispute. And so if the creditor has not filed a lawsuit, then there's nothing for you to push into arbitration. And unless the creditor filed like an arbitration, then you'd respond to it. So short answer is probably no. There'd be no reason to try to push that in there if they haven't actually done that. Follow-up question to that: can public records be sealed? They can, but you're going to have to reach out to the court. Each court, interesting enough, I just had a hearing this afternoon in a debt buyer matter, and the debt buyer is going to be providing some documents, and they're wanting those documents sealed. And we asked the judge, the plaintiff's attorney says, how's that work? And the judge said, I'm not really sure. I think that he says, talk to the clerk of the court. So this was Superior Court. This was big court, in Arizona, full-time real judge kind of thing, and they don't know. So you need to contact the clerk of the court. They can talk to you about how that is. So, all right. Let's see what Natus has here. One of our members, appreciate that, says, after the judge ruled to stay arbitration for 4 months, if no one files for arbitration after 4 months, what would the judge rule after this? This is a great question. So, and if you're new to the channel, you're seeing a lot of these questions about arbitration. One approach that a lot of people will take in dealing with a junk debt buyer lawsuit is they will file a motion to compel private arbitration. The reason being that credit cards most have an arbitration clause in their documents that require that if there's a dispute between the parties, that it be submitted to private arbitration. They don't want it to go to private arbitration, they being the creditors, because it's very expensive to litigate there. And so one way a lot of these cases can be resolved is by forcing their hand and pushing it to private arbitration. But if you, this is what I do see this happen periodically. If you file a motion to compel, the judge may say, okay, you got 4 months to have this resolved through arbitration. If not, the question here is, what's going to happen? If you, and this is where it kind of gets into, a game of chicken of who's going to file the arbitration matter. If you're in to me, my opinion, and if my opinion is based upon reading a lot of these arbitration agreements, it requires the party who has a claim against the other one to actually bring it. So I would argue that the creditor needs to bring it. And if it has that language in there specifically, I think you're in good standing to not do it. And then even if you go back and the judge is like, how come you didn't file it? You can point and say, look, they're supposed to do it. They didn't do it. You can file it. And again, this is, if you look at the online tutorial I have on this, there's JAMS and AAA, American Arbitration Association. You can go to their websites and see the fees there are dramatically less if you're the consumer. So you could file it. It'll only be like a couple $100. My guess is that they will probably dismiss at that point because the filing fees can be a couple $1,000 plus. And particularly if it's a small account, that may be a reason that they're not going to push it forward. So, all right, let's look at what King Arthur has to say. All right, do debt buyers check your credit file to see if it's worth pursuing legal action? Yes. Not only do they check your credit report, they go all out. Particularly, most of the larger debt buyers, I actually read an article about this in the Wall Street Journal a little while ago about some of the things that they do to be able to know whether you are a good person to go after. It's not as cut and dry as you might think it might be. They get something called a trigger report. So Experian, Equifax, TransUnion, all three of them, they sell your data. You can go there Just Google trigger report. And what it is they look at your credit report for different triggers that come through. Like if you buy a home, or if you buy a car, or if you sell a home, if you get a new credit card, something that indicates to them that now all of a sudden you have more access to credit, or you're in a better situation, or if they see a new job pop up on your credit report. All of those things, they get notified to the junk debt buyer, and then they'll file suit. I always hear people say, "Oh, this came at the worst possible time. We're just getting ready to buy a home." It's not a coincidence. It's because they're getting that information. And that's why, it's always kind of funny to me that the credit reports, the credit bureaus, people view them as almost like this quasi governmental agency. And I understand that, because they it messes with your life so much. These are private companies. Go to their websites. They take the information they get from you, and they're supplied by their creditors, and they sell it to the creditors. They sell it to third parties. They do anything they can to churn more money on it. So the answer is yes, they absolutely do that. They also will do a skip trace to determine as far as assets. These things are like through LexisNexis. These things are very cheap for them to do, to determine if you own property, if you have other assets, work, all that kind of stuff. So absolutely. Thank you, Dave. We got regulars here. I appreciate you and Alex and everybody every week checking in. I really appreciate that. All right. Let's see what Vanessa has to say. Thank you for being here for us. We're here. Is Wells Fargo hard to negotiate when there's a lawsuit going on? Is it better to hire an attorney, or is it possible to get a good outcome on my own? Of course, it's always better to hire an attorney. That's my self-serving attitude. You don't need attorneys all the time. So here's how I break creditors down to. When I see a debt collection lawsuit, I look to see if it's an original creditor like Wells Fargo, or a junk debt buyer like Midland, Unifund, Portfolio Recovery, Cortez, all these other junk debt buyers that are out there. If it's an original creditor lawsuit, they're going to require more, particularly if there's been a lawsuit filed. And the reason is they have their ducks in a row. They have documents. They're going to have witnesses. It's all in-house. They didn't sell it. They didn't transfer, just a spreadsheet to someone and tell them to try to go sue on it. So you can still negotiate it, but with an original creditor lawsuit, I always tell people to plan on a 60 to 80% settlement rate. You're going to get less out there, and you're going to see people say, I got less. I'm just going to say, if you have that mentally and you get something better, then great. You're going to have to really show a lot of facts, as far as hardship, what you're going through, if there's been a job loss, if there's been medical issues. Be prepared to show that, and even go with that initially and say, look, here's the hardship situation I'm in. And the good thing to know is that when it comes to debt collection lawsuits, if you're talking settlement with them, that can't be used against you. Rule 408 of the Rules of Evidence states that settlement discussions are not admissible in court. And the idea there is they want the parties to talk. They want them to see if there's any kind of middle ground that can be reached. And so you can reach out to them with that information without worrying that it's going to harm you overall. So, man, everybody's chipping in today. Thank you, Spidey Time. That is awesome. I think that's a new record here for us. And Natus, appreciate it with the stickers. Same with Michael T. Thank you. Appreciate it each and every week. And we have a lot of the members there from the Facebook group. I appreciate that. All right, let's see what Tiffany has to say. Chapter 7. So we're talking Chapter 7 bankruptcy here. What if your home exemption for filing Chapter 7 is over the maximum exemption amount, just over a few thousand? Is there any way to still keep the home? This is a humongous issue right now in the state of Arizona, because housing prices are going through the roof. Which is a good thing normally. It's a bad thing if you're needing to file Chapter 7. So, for example, here's a scenario that I'll make one up here. In the state of Arizona, you need to file Chapter 7 bankruptcy. Let's say that you have more than $150,000 of equity. $150,000 is the current homestead exemption. That's how much equity is protected. So let's say that your house, that you owe $100,000 on your mortgage, but your house is worth $300,000, or let's make it easy. Let's say it's worth $400,000 now. So you have $300,000 of equity. Or even if we want to make it a little bit closer, let's say you own your house free and clear, but it's worth $160,000. So you only have $150,000 of it that's protected. So the question is, if you file Chapter 7, are they going to take your home? I get nervous anytime there's non-exempt equity in a home. If it's a few thousand over, usually that's not going to be an issue, because when they take into consideration if they're going to sell the house, they have to run a hypothetical sale, they being the bankruptcy trustee that gets assigned to your case. And so they have to, include closing costs, realtor fees, all that. And so assuming that, in your market, it's the normal percent, you need to evaluate that. There's probably 10 grand in closing costs. Then no, they're not going to do it. But you need to be just dead certain on your values. And that's what makes me a little nervous right now, is that the values are kind of up. There's not so much down. Most of them just keep going up like every month. So when I do consultations in bankruptcy right now, I look up on Zillow as we're talking. And I know if there's real estate agents out there, I know Zillow's not perfect, but it gives you an idea, it gives you a range of where it's at. And if someone's over 150,000 in Arizona, I'm telling them right now to wait until January, because in January, our homestead exemption goes up to 250. You need to look in what the exemption is in your state. The homestead exemption is going to be state specific. And in some of the eastern states, I'm shocked at how low it is. I think it was like Kentucky or Tennessee, it was like 20,000 or something. I don't know how anybody files bankruptcy if they own a home. You need to make sure. But there's also some states like Florida where there is no homestead exemption. I believe Texas is that way, so the house can be worth unlimited. So something you got to be really careful. It's something to definitely meet with an attorney about if you're worried about losing your home before you jump into any type of bankruptcy. All right, let's see here. Midland Credit Management, Inc. sent me a summons. I'm in North Carolina, and it's only a debt of $1,500 after fees and penalties, but the actual debt is about $600. Can I please do a start to finish step by step? I can give you an overview of what the process is like. Check the link at the top of the chat box area there. That has the link to my online tutorials that go step by step. Though that has a lot of video. I mean, there's a couple hours worth of video that takes you through with templates and all that. So Midland Credit, so they serve you. And granted, I'm not licensed in North Carolina, so these processes may be a little bit different there. That's why I would say get legal advice there. But generally how things go is a complaint is filed, it's served, and then there's a certain period of time which you have that'll be written in the summons, and it will tell you how long you have to file a written response. It's usually called an answer. That you have to file that answer within a certain amount of time. And it's vital that you get this filed timely, because in most states, there's not a grace period. If you're 1 day late, you're done. They win kind of thing. And the answer is really just you admitting or denying the allegations that are contained within the complaint itself. So the first step is filing an answer with the court. Then in most states, there's some kind of disclosure or discovery period that goes on where the parties have to exchange information, exchange documents, potential witnesses. Sometimes there's formal discovery, like what I was talking about early, the request for admissions. Those can be exchanged, interrogatories, requests for production of documents. Usually about that time, most debt collection cases, they're going to hit you with a motion for summary judgment. Motion for summary judgment is the number one area that trips people up that are actually participating in this. A motion for summary judgment is essentially the collector saying, hey, judge, we don't need a trial. Just look at our documents and tell us we win. If you don't respond to a motion for summary judgment, in most jurisdictions, they can interpret that as your consent that it be granted. The court still has to go through it and take a look at the documents. I can tell you in my experience, if you don't respond to it, you're done. And it's much more complex than responding to like the complaint and the answer. It's not just admitting or denying, but it's actually substantively going through and responding to it. If you get over that hurdle, then in most cases, they're going to set a trial date for you. There can be other little variations. In Arizona, they have something called compulsory arbitration in cases over $10,000. So there's kind of little deviations. That's the general process. Surprisingly, in Arizona, it takes forever. Even in justice court, where we deal with under $10,000, to get a trial date, it's going to take you almost a year. In cases over 10 grand, probably 18 months. Other states, I've heard they do it on a very expedited basis, where you may file an answer and then you have trial in 30 days, 60 days. So that's kind of an overview. Like I said, I have that tutorial that goes into a lot more detail on that. but that's kind of what you're looking at here. The defenses, I'm going to ask you to, because I saw there was a follow-up question about what some of the defenses are, particularly for Midland. Check out the channel. There's a ton of videos on the defenses and really getting into the nitty-gritty of looking at the bills of sale. Was your account included in the transfer? Do they have witnesses that can even get these documents admitted into court? There's a lot of different steps on it. So, but I appreciate the question on that. So, all right, let's take a look at this one here. If we default on credit cards, we shouldn't apply for new cards. I've always wondered why they won't budge on settlement. I agree with you. I remember I heard a bankruptcy judge talk to this was something totally different. It was reaffirmation agreements in bankruptcy. It was Ford Motor Credit. Ford Motor Credit would repossess cars after bankruptcy, even if people were current on their loans. And the judge had one of the representatives from Ford Motor Credit, and he said, "Why do you guys do that?" He's like, "Yeah, these people are in bankruptcy now, but if they're willing to make their payment, let them keep their car and just pay the car off, because one day they're going to need to buy a new car. And I can bet you if you do this to them, people are going to remember Ford Motor Credit treated me horrible, and I'm not going there again." And so I think it's just bad business. But I have my brother-in-law works for one of the big car manufacturers, and he said, these giant companies, policies get put in place, and everybody just follows the policy. Logic does not govern a lot of this here. So, all right, let's see if we can do a couple more here. Oh, hey, thank you, Wales. What will happen during a bankruptcy Chapter 13 if you get into a car accident and have a total loss? This is a good and can be sometimes complex question. So Chapter 13, there's different chapters of bankruptcy. Chapter 7 is typically fairly short, 4 to 5 months. If you get in an accident in a Chapter 7 after it's filed, it's really not part of this because it happened after you filed bankruptcy. Even if your bankruptcy is still pending, something like that is not really going to play a role. Now, if you had the accident before you filed Chapter 7, it's a bigger issue. But if it happened, a month after you file it, that's not a big issue. Chapter 13 is different, though, because it's a much longer process. Chapter 13s are 3 to 5 years, and any monies you receive can become part of what's called your bankruptcy estate and be distributed to your creditors. So if you were to get in a car accident, and I know this is a little bit different than what you're saying, Wells. I'll get to the specific question. But if you get a car accident and you're in a Chapter 13, and let's say that the other party's at fault and you can sue and get money, technically the bankruptcy court can step in, litigate that, and try to get the money and make that distribution to your creditors. Definitely 100%. If you're going to be in a Chapter 13, get an attorney. I talked to one of the Chapter 13 trustees here once who's been doing this for like almost 30 years, said they had never seen a self-represented person get through the Chapter 13 process ever. And that's not to disparage anybody. It's just it's a very complicated process, ton of moving parts, long process. But to get to your question, Wales, as far as the loss on the vehicle, you can just, if there's no insurance payout, and if you hit a tree or something, you can surrender the vehicle and not owe anything on it. But then if you need to go get a new vehicle, particularly if you need to finance something, you have to get approval from the court to be able to incur new debt there. All right, let's see. This is a good one. During a court dispute, if I move from Illinois to Arizona during a job relocation, can I hire an Arizona-based lawyer like you? Not if it's in Illinois, not if the lawsuit was filed in Illinois, unless the attorney is also licensed in both states, or there's a process being called admitted pro hoc vice, which is, I think it's Latin, where you can get admitted for a specific case. Debt buyer cases like this, super rare for that to happen. So you would need to hire someone who's actually licensed in that particular court. So, all righty, let's see here. Let's do this one. Collection Convergent took money from my daughter's bank account, an ambulance bill for your son. Can I take them to court? ACC was open when she was a minor, so my name was listed, but no, she's no longer a minor. Okay, so I do see this happen too quite a bit, where exact scenario, everybody has this with your kids. You open up a minor bank account because they're under the age of 18. So you're on there as well because you're the adult. And then they turn 18, they go to college, and you don't ever change the how the account is held or owned. And then creditor comes in, particularly, they have a judgment against mom or dad. They swoop in and sweep money out of the kid's account, which you don't even use. And then kids are mad at you because they don't understand where the heck all their money just went. If there's a garnishment like this, you can actually, you can object to the garnishment. If those funds in there are not yours, you can raise an objection to the garnishment. You usually have to go into a hearing, be able to show that, maybe with monthly statements or something saying, look, this account was open when they were like 12 or 13 or something. This is not our checking account. These are not my funds. My daughter's working and these funds are coming in, and, or this is money from grandma and grandpa from birthdays and stuff like that. I have seen that the courts are generally pretty sympathetic to that and will generally not push the issue. So they'll go ahead and refund that. So, all righty. You know what? I think that's going to probably do it for today. But I appreciate everybody checking in once again. Hey, we had a good group today. Appreciate everybody checking in. We do this each and every Thursday. If you have questions, feel free to reach out. If you want to check out some of our online tutorials, again, there's a link at the very top there. But I appreciate you all checking in, and we will